What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Friday. We made it. End of the week. Hope you guys all had a great week. Let's have a great weekend. All right. First case. First case is a good one. It's a continuance of I played the part 1 a few weeks ago. I tried to find it for, so I could put the link in the description, but it was one of the second or third clips, so it wasn't on the thumbnail. So it's going to take me a little bit longer to find it, but I will. For all you that are watching later, I will drop it in the description so you'll have the part 1. But this is part 2. Yeah, grandma's trying to evict her daughter. I don't know if she's a grandma or not. I'm just saying that because she's elderly. Probably shouldn't do that, but we're all on the same page. All right, before I hit that play button, you know what to do. Hit the like, subscribe, do your jump kick backflips. Let's go.
Ms. Stepka, are you here for Ms. Williams-Smith?
Yes, good morning, Your Honor. This is Erin Stepka on behalf of Margaret Ann Smith. I am checking my email to see if perhaps some reason she is having an issue logging in and seeing if she might have tried to call. If you could give me one moment.
She's here.
There we go. Thank you. Yes, thank you.
All right. So I think this was.
Are you referring to my mic? Is my mic acting up tonight? That's not good. We just started.
Was that once before? Has there been a resolution here? Mr. Popovitz?
Thank you. Just procedural clarification. We had an original hearing in this case. Miss Williams, Margaret Williams, appeared, asked for a delay to seek legal counsel. She then secured the services of Miss Stepka, and Miss Stepka reached out to us the day or two before the hearing with an appearance. I think it was an answer in affirmative defenses. Miss Stepka and I, before I think the last hearing was April 4th, that was the adjourned hearing. Miss Stepka and I agreed to terms of a consent judgment. Those terms were placed on the record, and a consent judgment consistent with those terms was approved and filed with this court and entered. Today's hearing is a motion brought by Miss Stepka on behalf of Miss Peggy or Margaret Williams, who I see has left the screen. I think she was having she must have been having some connection issues. But this is a hearing on a motion for new trial. Miss Stepka has filed a brief. We have filed a response brief, which I hope you've had a chance to receive and review. And then Susan Williams and I assume Michelle Faribault are on the same window and screen. And Miss Williams, if you can hear me, you're welcome to put your camera on and attend if you want to watch. And she's here to see the outcome of this motion for new trial following entry of consent judgment.
All right, so I apologize. I wasn't aware that there was a motion, and right now I only see Ms. Stepka's motion. I don't see the response. Anywhere, Amanda, can you see a response?
I am. We did email it to the court. Part of the confusion here procedurally, and I think Ms. Stepka, there wasn't any ill will intended, but Ms. Stepka filed her motion without sending us a copy, waiting for the court to schedule a hearing date rather than filing the motion and serving us with a copy. The reason we were made aware of this was because the court scheduled the matter for hearing today. We received a notice of hearing. I was actually shocked that I hadn't received the pleadings when I got the notice of hearing. I called Ms. Stepka. She advised me that it was something that she was involved in, and she was waiting for the hearing date to serve the motion. Quite frankly, we've never technically been served the motion. We received a copy by mail last week, but there's been no proof. I didn't see any proof of service included. We received it late last week, but we had secured a copy earlier than that from the court clerk through our own inquiry, our separate inquiry, and we did file the response.
Well, all right.
I did file a proof of service, Mr. Popovitz, just so that you're aware.
Okay. I didn't see a copy of it, so that's why I was saying.
All right, real quick before I get too far, and I don't want to forget, Kathy Berry, thank you so much for the 5 gifted memberships. I appreciate it. And welcome to all the new members. We are, 3 days away from Members Monday? Let's go. All right, thank you so much, Kathy. I appreciate it. I almost called you Carrie. Kathy. Kathy Berry almost came out as Carrie. At least it kind of makes sense when you say it really quick. It doesn't. It doesn't. I will not mispronounce your name, Kathy. Thank you.
Okay, so it's quite a long response here.
Well, the response, the pleadings itself, Your Honor, the pleading itself is fairly straightforward. There's a response to the allegations as stated, and there's a brief in support. The length of the document, as you see when you pull it up in PDF form, is there are some copies of pleadings in an Oklahoma guardianship case filed on behalf of Susan Williams that were attached as exhibits. Your Honor, if I may elaborate as to the nature of this case, Miss Margaret Williams has incredulously filed a guardianship action on behalf of her mother in Oklahoma. Her mother is of sound mind and body and has medical documents that are attached to our response that attest to that. She also has separately appointed another daughter, Michelle Faribault, as her power of attorney. So the guardianship proceedings are ill-advised, to say the least. But the consent judgment was entered prior to the April 4th hearing because there's no issue here of fact. Miss Williams, Susan Williams, owns this property. There is no lease. If you recall from even your first hearing, Your Honor, there was a comment made by Margaret that she thought she could live there forever. And I think Your Honor responded appropriately, said, well, I guess she's changed her mind. So we were continuing with the possession action. So we're here today in their attempt to set aside, I suppose, or ask for a new trial where there wasn't a trial to start. There's been no affidavit supplied with their motion advising of any new facts that were available. There's commentary as to new facts as alleged in the pleadings, but there's no basis here for the motion for new trial. Quite frankly, there was no trial. Perhaps there'd be another procedural avenue to set aside or seek relief from an order, but that's not been filed. This is a delay tactic, and it's precipitated upon the request for this court to somehow honor or recognize pleadings and actions taken in Oklahoma for which none of us appearing before Your Honor today have the ability to attest to or describe the nature of or the status of.
All right. Do we remember the grandma now? Bottom right corner, the one that just sits there and doesn't move, that we were kind of worried about last time we were on. You might remember her now that she turned the camera on. Also, now I like Cooligan, definitely not Cromwellians. I think that goes better. But yeah, colonist, I like that too. What was I going to say? It is what it is. Thank you so much for hanging out with us. I'm glad that you found the channel, and we are happy that you're here.
Quite frankly, the medical documents that we've attached to our response reflect that Susan Williams, who's here on camera, is of sound mind and able and capable of making these decisions. If she's not, she's already appointed one of her daughters as a durable power of attorney. Quite frankly, that daughter lives where Miss Williams does in Oklahoma. Margaret Williams lives here. She has no understanding or information relative to her mother's financial condition. Quite frankly, her mother needs her to move out of this property so she can sell this family-owned cottage so she can apply those proceeds to her living expenses at a living center in Oklahoma. The delay that's being put by this daughter who wants to be her guardian is a clear indication of her lack of knowledge or understanding of her mother's financial condition. We were very fair and gave her additional time under a consent judgment. There is no bearing or basis for the motion for new trial. This motion should be denied. The consent judgment, which was negotiated with counsel, should stand. We've made a request for sanctions. We feel that filing is frivolous, not based on proper court rule. That being said, that's the secondary issue. What's most important here is Miss Williams, Miss Peggy Williams, Margaret Williams, is subject to the consent judgment, must move from the property so her mother, who owns the property, can sell it so she has access to those proceeds to help her with her day-to-day living expenses. Your Honor, if you need to hear from Susan Williams directly to substantiate or feel comfortable about a decision in her favor today, she's here. I see her back on the screen and now with camera. Susan Williams is competent to tell Your Honor exactly what I've just told you. She needs this money so she can afford to live at the center she's living, but she understands what she's doing. She understands she owns the property. She does not want her daughter, Margaret, to continue to live at the property any longer. That was what substantiated the notice to quit, and then ultimately the filing of the summary proceeding action, and then the consent judgment. So thank you, Your Honor.
Hello, Chris. Good to see you as always. I told you. You're on Rachel status now. You'll get a pause every time I see your name pop up. Also, Kayla. Thank you so much for the PayPal. I appreciate it. For Legal Fiction, did you miss this one? I love it. I love it. Thanks, Kayla. I appreciate it.
Well, okay, so there's quite a bit here, apparently, but maybe it's not too complicated, so to speak. Look, I'd like to read all the pleadings. Can the attorneys and Ms. Williams and Ms. Williams-Smith come back at 1 or 1:15? Would you have some time then? I want to take the time to read things. Can you do that or not?
Speaking for myself, Your Honor, yeah, I know Aaron has another hearing this morning, which is why we moved this hearing from 10:45 to 9. I'm always happy to work with counsel. Aaron's been good to work with in many other ways other than my concerns as to the filing of the motion. I'm happy to be back at 1 o'clock. I think my client can be, Susan can. And I have another hearing scheduled at that time in Circuit Court in Cadillac, but I will see if somebody else from my office can sub in and handle that creditor's exam.
Okay. Ms. Sika, will that work for you?
Yes, speaking for myself, it can. Peggy, does that work for you?
I think we're going to need Miss Susan Williams to do her jump kick backflips just to make sure she's okay. I think we do. What do you guys think?
You're on mute. Does it nod yes? Does it work for you? Peggy, you're on mute still, so we'll work on Zoom to make sure that works for 1 o'clock, everyone.
Yeah, I got you, 1 o'clock.
Okay, thank you.
All right, thank
so
you.
yes, Your Honor, that does work for us. If I may, as Mr. Popovitz gave, a rundown of their side of the story, would you mind if I spoke a few words for your context right now?
Sure.
Absolutely.
For Your
Go
Honor.
ahead.
Oh, I'm sorry.
Yes, go ahead.
So just, very.
Yeah, I agree with that. I do agree with that. But if you remember the last hearing, she was claiming, I'm going to say this again because I don't think it comes out as much. I think it may later in the second part of this. But the daughter, the one that's getting evicted, she's claiming her mom, her health is too bad. She can't make decisions for herself. So her sister is controlling the, all of her mom's, business. But her sister also has power of attorney. So, so if she's claiming that her mom isn't in the right state of mind to be making these decisions, you know what? She already has a power of attorney, so you can't really do anything about that. Just saying.
Abridged version of why we're here procedurally, given who there's no reason for a delay here. This is all based on the fact that there are procedural goings on for the guardianship of Ms. Williams in Oklahoma. So the decision on whether or not she would be able to evict someone, we expected that to have been made shortly after the consent judgment in this case. Unfortunately, with our understanding lacking, that decision was not made right away. So we thought that the determination of Ms. Williams' guardianship would have been done with by now, but multiple more hearings have been set, and that's not set for decision anytime soon. So that's a material change in my client's understanding of whether or not she would be forced to move out at the end of the period of the consent judgment.
Your Honor.
Yes.
What's being asked for you to decide here today is competency, and you're asked to overrule the impending proceedings in Oklahoma based on your authority through a summary proceeding. It is for delay. The request is for delay. There was a consent judgment. They were in as good a position as we were to know what would happen or what was scheduled to happen at that later scheduled hearing in the guardianship in Oklahoma. They're asking you to grant a motion for new trial off of a consent judgment, and to also, I guess at the same time, simultaneously, make some kind of preliminary decision that Miss Williams, Susan Williams, is not competent to carry forward with this action to take possession of her own home where there is no issue as to title. There is no issue that there's a written lease. So I leave you with those comments as you review the pleadings, and we meet back at 1 o'clock.
Well, go ahead, Ms. Sika.
Your Honor, we are not requesting you to determine Ms. Susan Williams' competency. Merely there has been a change as to the fact that there are other proceedings going on in another state regarding her competency and her assets as a result of that, and who has control over those. We're not asking for a decision on that, merely a reevaluation of the situation due to, the fact that circumstances have changed unexpectedly, and that the determination of whether the eviction should be carried through should wait until those proceedings have subsided.
Well,
It fell the cabin in order to cover my expenses here in Tulsa.
so
You being
look,
coached on that, Mom? Who's behind your chair?
all right, both of you, please be quiet. So we'll reconvene at 1. However, one quick response I have is there wasn't ever a trial. So this could be seen as a delay. It seems as though because there was a consent judgment, trial might have been waived and a motion for a new trial might not be appropriate. I don't know. I want to take the time, like I said, to read everything. So we'll reconvene at 1. And perhaps in the interim before 1, if the attorneys want to talk about possible resolution, that might be a good idea. But otherwise, we'll see everyone at 1. I know, Mr. Poppets, you have more cases today, but so we'll see at 1, Ms. Seekin. We'll see Ms. Williams-Smith and Ms. Williams at 1 as well, okay?
Your Honor, I would like, thank you. I would like to point out that the
Oh, sorry, Jen. I wanted to give you a shout out quicker, but I was waiting I thought the break was happening right then, but it looks like we still have a couple minutes. So Jen, thank you so much for your super sticker. I appreciate it. Very generous of you. Thank you.
While most likely the mistaken statute to submit this motion under the standards for relief from judgment or order are nearly identical to the standards for a motion for a new trial, and I expect to make that argument at 1 o'clock. Thank you.
Your Honor, just to clarify, that wasn't the argument that's presented in the pleadings. The argument presented in the pleadings is a motion for new trial. There are different court rules. The court rule relied upon by Ms. Sika in her filing is MCR 2.611D, which specifically requires an affidavit to be in support of the motion. There's no affidavit here. This is an attack against a mother at all levels, both in Oklahoma and here, to try to delay, because Miss Williams, Peggy Williams, has a tremendously negative criminal record. Other issues are outstanding. She has no involvement, no contact with her mother. It's only so she can continue to live for free. She's costing her mother a considerable amount of money by living at this property. Her mother's continuing to cover the electrical expense and other tax expenses. She simply does not have the finances to do so. It all goes to weight of the fact of why the guardianship hearing will ultimately be denied in Miss Peggy Williams, based on her motions or her actions in Oklahoma. But Your Honor, making a ruling to set aside the consent judgment and giving her an opportunity to stay in a property she has no legal basis to do so is asking this court to make a preliminary ruling on Oklahoma proceedings for which you have no involvement and really no experience. Neither does Ms. Sika or myself. It's simple. We had a consent judgment. Things are delayed. She filed an emergency action in Oklahoma. That was denied. There's pleadings attached to our response that were filed by the Oklahoma Council on behalf of Susan Williams to show why, in all likelihood, her ultimate guardianship action will be denied, but it's irrelevant for the purposes of this case. There was a deed. Miss Susan Williams owns the property. There is no lease. Summary proceedings allow this to take place. Not to mention, I don't even care if she is being coached on her screen. Miss Williams is there. If Miss Faribault is there with her, it's her appointed durable power of attorney. So the guardianship action is irrelevant and unnecessary because Miss Williams, while she's of sound mind and body, has already appointed somebody to take care of her finances and her livelihood for her, should she not be able to do so, which has not arisen yet. but it's the daughter for which she's close to, lives by her, and has the means. Both of them will testify that Miss Williams needs to sell this property so she can pay for her life in Oklahoma.
Okay. All right. So we'll see everybody at 1. Okay.
Thank you, Your Honor. Take care.
Thank you.
To
Oh, I was muted. I think the attorney for the homeowner, grandmama, I think he's doing a great job. Now the attorney, what is her name? Erin. She was hired by the what's a good name for her? A mooch? Yeah, a mooch is. Yeah, I'll just call her the mooch. So yeah, she's trying her best. She has a losing battle though. She really does. And this, the attorney for her grandma is knocking it out of the park. So yeah, good luck on this. Good luck on this.
decide this motion. So I've now had time to review the motion, the response, and the response brief. So under either rule, 2611 or 212-612, which seems like the more correct rule because there wasn't a trial that 2611 would address. But under either rule, it looks like the only possible prong of the rule would be with regard to new evidence, which I'll use 2612. So this would be 2612 CB, lowercase b, newly discovered evidence by which due diligence could not have been discovered in time to move for a new trial under 2.611 capital E parens. So I think what this comes down to is, I guess, Ms. Sika, what is the new evidence? And if there is any, how is it relevant to this complaint for possession here? So what's the new evidence? Let's start there.
Thank you, Your Honor. As I described in the document, we learned that it is not appropriate to attach the Oklahoma guardianship pleadings, so that is why they are lacking. If we do need to get a hold of that, we could make motion in Oklahoma to do so.
Run, Timothy, run. It is not your time yet. You don't want to be any part of this.
Essentially, at our previous hearing, it was my client's understanding that 2 days after is when guardianship of Miss Susan Williams would have been determined. While that does seem early in the process, as she had only recently filed those documents, as was stated earlier, none of us are versed in Oklahoma law, so we can't speak to that process.
Annalisa Molina. I've been waiting to see your name pop up. Thank you so much for your PayPal the other night. You weren't here when I gave you the original shout out, so I wanted to make sure I gave you a shout out while you were here. But thank you so much, Annalisa. That was very generous of you.
With that understanding, because it was a hearing on petition on that date, she thought there would be a hearing on that petition. What actually ended up happening was setting of future dates, and it was really just the start of the process. So with that, that's new information that Ms. Williams did not have previously and couldn't have obtained without going to that hearing. And because that litigation is ongoing rather than ceased as we had expected, we feel it is not appropriate to continue with the eviction until it's determined whether Ms. Williams' selected power of attorney is the appropriate guardian.
So how is...
I'm glad you stumbled across the channel too, Brett. Thank you so much. Also, I have a question. Where did you go? Where did you come from? Where did you go? How do you pronounce your name? I know Biggin called you Mike. And when he said Mike, I'm like, is that how you say it? Is that just what people call you, Mike? I mean, I guess it makes sense, but every time I see your name, I stare at it for much longer than I need to because I'm trying to figure out how to say that. So if you can phonetically say it, I would appreciate it. Or phonetically spell it. I mean, you could phonetically say it all you want. I'm not going to hear it.
Whether or not Susan Williams has a court-appointed guardian, how does that affect this proceeding? I mean, she's the plaintiff here. She owns the property. She just wants it back. How is a guardianship proceeding in Oklahoma relevant to her wanting your property back here? What could possibly be there in that file in Oklahoma?
It is our understanding that it is Ms. Williams' power of attorney who's really driving this decision. So if this consent judgment were to stand, then her current power of attorney would have the ability to enforce that eviction order. The guardianship will determine if there is another person who is more suitable to make decisions for Ms. Williams and who might not affect that order if that's not in her best interest.
To sell her property?
They
Not her
may
best interest. Go ahead.
They may determine that it is in her best interest and need to enforce the eviction. They may determine that it's not in her best interest and not need to enforce the eviction. As I said earlier, we're not asking you to determine what is in her best interest or if Ms. Farbaugh is the appropriate guardian or person to be making those decisions. Just that there is ongoing litigation that we believed would have ended and did not indeed end.
And that's the new evidence that the guardianship proceeding is continuing in Oklahoma?
Yes, and my client would not have entered into the consent judgment had she known that. And it affects whether Ms. Williams is able to make that decision at the appropriate time, whether to move forward with a written or application for eviction.
Well, obviously I can't determine her competency or I guess weigh in on the request for a guardian to be appointed for it. I think for this proceeding, her petition to, her complaint to take the property back, I think for that decision, I can consider the letter that's in the file that was supplied by Mr. Popovich from Dr. Lade, L-A-D-E, who's the medical director of Trinity Woods Assisted Living, where Ms. Susan K. Williams is. And that says that, in his opinion, she can make prompt and intelligent decisions regarding your medical and financial affairs.
Wait, is Peggy not here? I just realized Peggy's not here. At least her camera's not on. I don't think she said anything yet. She didn't come back? I mean, yeah. She has an attorney. I guess she doesn't have to. It's technically a civil matter. Maybe she doesn't have to appear. I don't know. But I would think that with all of her animations and, everything she wants to say, she just doesn't show up.
Dated March 27, 24. Anyway, Mr. Popovich, what would you like to say in response?
Thank you, Your Honor. I appreciate the time you provided earlier today at the original at the initial hearing on this matter. I think what gets lost in let me back up. I think procedurally there's issues with this motion. The argument isn't consistent with what took place because there was no trial. It's potentially, as we discussed briefly earlier today, and then you've touched on now, it's potentially an MCR 2.612 motion, but even there's not enough basis for it to be granted. This was a consent judgment negotiated between counsel. It wasn't even negotiated with an unrepresented party or two unrepresented parties. It was between counsel. The fact that Miss Margaret Williams didn't understand or know that there was not going to be a decision, or she learned later that the decision would be delayed in the guardianship, is neither here nor there. It's not new information. It was a new development afterwards where she regretted potentially the consent judgment, but nothing changes the fact that Susan Williams is the owner of this property. Susan Williams can tell you today, if you give her the opportunity, that she needs to sell the property for her own financial livelihood. She's been moved from a patio unit to a more assisted living unit in Oklahoma because of physical issues. She needs more care in that regard, but she's mentally sound to make decisions. I mean, one thing, all of these arguments that are being made as far as guardianship implies she needs a guardian. She doesn't need a guardian. And to the fact that she does need assistance from a durable power of attorney nature, she's already appointed her other daughter, who's happens to be there with her and more familiar with her financial circumstances. She simply needs her estranged daughter, Margaret, to move from this property, and so she can sell it. And arguing the context of a guardianship hearing from another state is merely I consider it a tactic for delay. It existed at the time we worked the consent judgment out. It exists today. I think that motion and that action in Oklahoma is frivolous. I think this motion was frivolous to further delay the entry of an order of eviction. It's a simple matter. She received a 30-day notice to quit. There was a contested action. She took time to secure legal counsel. She got legal counsel. We worked a consent judgment. There's nothing more that should be considered by this court than those relevant factors. Trying to make any kind of insinuation as to what would happen in Oklahoma is probably just not appropriate for any of us at this point. But I can feel comfortable in my dealings with Miss Williams and her daughter, Michelle Faribault, that I'm sure those actions will be decided in favor of Susan Williams. She doesn't need a guardian. She's competent. And Your Honor, thank you again for your time.
So Dr. Faribault is currently Susan K. Williams' power of attorney for financial affairs. Is that right?
Well, just as if anyone else, remember from an estate planning standpoint, let's take a step back here for a second. You appoint durable powers of attorney when you're of competent mind to do so. If you don't do that, and then you end up losing your faculties or capacities, you need a guardianship or a conservatorship to step in because you're not able, because you didn't appoint someone when you were competent to do so. Susan Williams is still competent. She's making decisions. At the time where she's unable to make decisions, Michelle Faribault already is her durable power of attorney. There's no need for a guardianship action to be taken now or in the future because she's already, while she's of clear mind, made the decision that should she become physically or mentally incapable of handling her financial matters, her daughter, Michelle, has that power. But I'm not here on the direction of Michelle Faribault as the power of attorney. I'm here because Susan Williams wants me to be here because Susan Williams needs this property for which she owned with her husband, for which she let her daughter Margaret live in for a period of time. She needs her to move out so she can sell the property. Because she has a daughter that cares for her and is there with her, it's not her guardian. She's not acting on the durable power of attorney. She's there as a concerned family member for her elderly mother who needs moral support in this case. But Susan's been here at every hearing and she's comfortable with the decisions and she's comfortable with the subject matter before this court. And she's not being forced to do anything she's not comfortable with. In fact, the further delay in this case makes her more uncomfortable because it negatively affects her financial condition.
Okay, thank you, Ms. Sika. Anything else you'd like to say?
While Dr. Faribault is the current power of attorney, that is precisely what the guardianship matter is about in Oklahoma, and is whether this evaluation of Ms. Williams was properly determined to determine if her competency is found the same by another physician through the Oklahoma court proceedings, and whether Ms. Faribault is the proper party to be caring for her in the event she is not competent. That was expected to have been decided, which is why the consent judgment was entered into, because that is now ongoing. That's a changed circumstance that my client couldn't have been aware of at that first hearing.
All right, well, as I stated, under either rule 2611 or 612, I think the key, well, it's been stated actually that under either of these rules, and it really should have been under 2612, I think, because it wasn't a trial, it was a consent judgment. But the only thing that I could consider would be whether
she's got nothing to work with. She really doesn't. I mean, I'm not a lawyer. I can't say if she's, it sounds like a weak argument, but I mean, when you're grasping at straws, I guess you're trying to pick up all the little pieces you can, and she's trying at least. Not like Peggy didn't even show up.
there was material evidence that was newly discovered that with reasonable diligence could not have been discovered and produced, I guess at the time or prior to the signing of the consent judgment. I don't feel that the pendency of the guardianship proceeding in Oklahoma is new evidence that this court should be considering in a complaint for possession of property. So I'm just going to deny the motion. I'm not going to order find some costs. I'm sorry. I'm not going to order attorney fees.
Nope. I'm a judge. I'm a judge, not a lawyer. Colin, definitely not a judge. Oh, see, okay. I told you guys I would have that video out today, and I spent all day waiting for that Judge Simpson case I put out this afternoon. All right, that needs to be my main focus for tomorrow, but I'll put it out. I've already teased it to all of you guys who are watching the stream the other night, but I need to add the pictures to it and add the commentary and then put it out for everybody else. So that needs to happen.
I'm not finding that the motion was frivolous. No sanctions. So the motion's denied, the judgment stands, okay?
Thank you, Your Honor. Would you like our office to prepare and email over an order denying the motion for new hearing for the reasons stated on the record?
Yes, please.
Okay. Aaron, because of the timeliness involved here, I'm going to submit that to the court. We'll copy you on the submission rather than doing under the 7-day. If you do have any issues, though, where you'd be filing an objection to it, just call me and we can work through those before that's necessary.
Okay, thank you, Gary.
All right, thank you. All right, Susan,
Okay, we're all
Michelle
set.
Faribault, thank you for your time.
Thanks, everybody. Take care.
Thank you, Your Honor. Take care.
Take care. All right, so we'll go on to the next matter.
Yeah, she showed up just to see the look on everyone else's face when she lost. Our guest, she showed up to show her face when she felt defeat. Yeah, that was. I think everyone agrees that was the right call. That was I don't know. It's a shit tactic by the daughter to try to argue for competency to try to stay in the house for free when your mom needs the money. Come on. All right. What's next? Oh, the next one. The next one isn't a crazy interesting case, but the attorney says some things to the judge that's going to raise everyone's eyebrows. And if you're like me, I've thought about why do the judges give these bond conditions that are just basic laws? No driving without a driver's license. Yeah, that's a law. Why is that a bond condition? So every time I hear that, I always kind of smile. This attorney actually calls the judge out for it. And yeah, we'll get to see the judge's response. All right, let's go.
Morning, gentlemen.
Morning.
Mr. Heflin and you are Patrick Heflin. We're on the record in case number 24-1892SD. Sir, you're appearing with your attorney, Mr. Williams, for arraignment purposes this morning. And Mr. Williams, did you have opportunity to review the allegations on the complaint, nature of the offense, and the possible maximum penalties with your client?
I have, and Mr. Heflin will stand mute. He will waive a formal reading of the complaint.
The court would enter a not guilty.
Giz Rock. Yeah, I've been lacking on that. I've been lacking on your interest in music. I'm gonna find something. So that's on my to-do list for tomorrow. I'm going to put out the court crawl video, and I'm going to get Skizrock his theme music. But yeah, it can't be copyrighted music though. So I got to use it from the site that I pay for a membership on. So I'll find something. I might send you a couple clips to see which one you like the best. No, I'm not going to do that. You're going to be surprised. But anyways, I should just say thank you, Skizrock, for the super chat, and let's go.
And you also had an opportunity to review his trial rights, Mr. Williams?
I have. He will, for today's purpose, he will exercise his right to remain silent. He'll obviously answer questions about addresses, contact info, but he understands the process this morning.
Thank you. So, Mr. Heflin, a not guilty plea would be entered by the court. The next step in the process, the pretrial conference in this case, will be scheduled for May 23rd. Mr. Williams, do you have any conflicts with that day?
I'm just looking right now. I actually have to be in Antrim, but just schedule it. I'm filing a motion. I just got an updated letter from my doctor yesterday. addressing my pretrials. So just schedule it and I'll figure it out. I have enough time.
Okay, well, if you have to be an interim, I would prefer that we schedule at a time that you might be available, even if you do file that motion. How about the 21st?
Well, the point of the motion is I'm going to try to limit the compounding driving. I have a disease, degenerative disc disease. I'm in physical therapy currently. I've been in physical therapy now twice in the last 14 months. I'm trying to avoid a surgery. So I'm going to file the motion and then I'll address it with the court appropriately. So just please schedule it on that day.
Okay, so it will be scheduled the 23rd, May 23rd. It's at 9:30 a.m. It's an in-person appearance, and Mr. Heflin, the court will mail you that notice as well. Mr. Williams, is there information that you would like me to know regarding bond? I do show that Mr. Heflin posted an interim bond, and I will continue the interim bond. Is there information that you'd like me to know regarding testing?
Yes, he has a trip in Ireland that he's May 4th to May 18th. So I want the court to grant him to travel those dates. As far as testing, obviously, I always defer to discretionary. If the court's going to test him, I've discussed this with him. He could rent a mobile device, but those are the issues that he currently has.
Okay.
Thank you so much, Ian. Member for 3 months. That's awesome, man. Thank you. I appreciate it.
My only concern is the allegations with regard to the blood alcohol level. And so I was going to offer that I was going to order that Mr. Heflin would take him past random PBTs. I'm willing to allow him to leave the country between May 4th and May 18th, at which time he would not be required to test. But Mr. Heflin, if you have an in-home device, if you rent a machine and have an
the judge upheld the daughter that was living in the house. So Peggy filed a motion for a new trial because the daughter already lost. So she filed a motion for a new trial, and I believe that was rejected. So yeah, so she has to move out. That was the conclusion of that. I think I'm right on that. But yeah, the mom won, grandma won.
In-home device, I would order daily PBTs. If you choose, I would order 8 times per month random PBTs, and that would mean that you'd have to call a number each evening to see if the next day you would have to go in and test between 6 and 9 a.m. That would be at New Directions, which is on South Airport Road. Obviously, that's less expensive, but it's time consuming, and it's driving. So which of those would you prefer? Would you prefer the in-home device or the 8 times random?
What was the cost for the in-home device?
So I'm not positive about that. And frankly, it's probably about the same price as daily PBTs going to New Directions. Mr. Williams, can you shed light on that?
Yeah, I would say it would be nominal, but between your time, your gas, you're not talking about a big swing there. So I would encourage the in-home device. That way you don't spend your days every day and worrying, and you can just do it and be done with it.
Yep, let's do the in-home device.
All right, so Mr. Heflin, I'm going to, as conditions of your bond, I'm going to order that you may not use nor possess any alcohol, any illegal substance, any.
Okay. I told you at the beginning that the case was, just kind of boring, kind of run of the mill, but this is when it gets interesting. The bond conditions and the Mr. Williams, the attorney. It gets funny. It gets funny. Annalisa Molina, the most fun name to say on the internet. Thank you so much for the 5 gifted memberships. I appreciate it. Welcome to all the new members. Yeah, Members Monday, 3 days away. Let's go.
Any controlled substance, including marijuana, any mind or mood altering substances, or any non-prescribed medication. You would provide a list of your current prescriptions to the district court clerk. You will take and pass daily PBTs, proving you're not drinking. You would also submit to discretionary PBTs and discretionary urine screens whenever requested by a police officer or any court personnel, so you may not refuse.
Yes, this is a DUI.
Where are you currently employed?
I'm a call. It's a restaurant downtown.
Okay, I think I noticed that. So I'm going to order that you may not enter a bar, casino, or any place that's main purpose is to serve alcohol except for work. You'll have no threatening, intimidating, harassing, or violent behavior towards any person, and you'll be respectful of all court employees and care providers during the course of your case. You may not operate a motor vehicle without a valid driver's license, registration, and insurance, nor with the presence of any alcohol, any illegal substance, or any controlled substance, even that which might be prescribed to you. I'm also going to order as a condition of your bond that you may not get any moving violations. So any traffic related issues, please.
I'm going to object to that. I don't know where that condition came from or whose idea it was, but it's arbitrary and I don't know. I mean, that's bizarre.
Absolutely not. Do you know what the allegations is regarding the traffic stop, Mr. Williams?
Who cares if he ended up getting a civil infraction by accident and that violates his bond is absurd. So I don't know whose idea that is, but I'm objecting to it, just making the record because that's crazy.
That's fine. So Mr. Heflin, I am going to order that you may not have any traffic violations, moving violations with regard to driving.
So are you ordering that he obeys the traffic laws?
Yes, that's it.
Well, I mean, that's presumed.
Not.
It is. It's presumed. So, all right. I'm just saying, I don't know who came up with this idea, but it's bizarre. I'll just make the record.
Thank you. I did, and I don't think it's bizarre. So thank you very much, Mr. Williams.
Well, it's unenforceable. I'm just telling you, if it became an issue, you can't order someone to do something that's presumed. It's like I order you to. It's an arbitrary and bizarre thing to order, because what if somebody accidentally? What if they accidentally get a traffic violation? What if they have a brake light out they don't know?
That's not a moving violation.
Or what if they?
All right. Again, what I said at the beginning of the video, I've always had questions about these bond conditions. What did I say? The example I used was don't drive without a legal driver's license. Like, yeah, no, that's a law. Like, why is that a bond condition? I never understood that. So I'm actually finding it really fascinating that this attorney is actually calling these bond conditions out. The judge will explain it here in a second. And yet he's being a little disrespectful. He is, but it's his job to advocate for his client. And he's like, this doesn't make sense. Why is this a bond condition? It's his job. I just like that the argument actually happened. I know I'm not the only one that's ever thought that, but I do like how I saw this, and the judge lays it down.
Only a moving violation, okay, and it's not arbitrary. It has to do specifically with this case because you see, I set bond particular to each case in front of me, and in this case, part of the allegation is reckless driving, and in this case, that's a charge. That's count 2, right? So I am going to order that he may have no moving violations. I also order that he may not operate a motor vehicle without a valid driver's license, registration, and insurance. Those things are also presumed?
Correct. Those are presumed. And
okay.
But those are criminal, though. And I would say that you could order things.
Is?
It doesn't matter. I mean, it just seems like a overbearing thing to do on a non-serious misdemeanor with the presumption of no jail, no probation, but it's fine.
I'm glad you made that record.
Thank you. And I appreciate you. I do. I'm just saying it's It's
Bizarre, I know, I heard that.
it's unique.
Mr.
How about
Heflin?
that?
May I verify your contact information, please, sir? What is your phone number?
231.
Ooh, I must miss that. I must miss that.
Mailing address, please, sir.
All right.
So the 86th District Court can email you a copy of the referral form regarding the testing. May I have your email address? Thank you. So by 3 o'clock this afternoon, you'll get that email. Please check your spam folder or your junk mail. It might go there.
Yeah, the attorney's about to take like a major leave of absence because he has some kind of medical thing. Was that in this video, or did he say that before I started? I grabbed the clip. I actually don't remember, but it's in my head. He's got some major medical thing going on, and so I'm guessing he's just not in the office and he's doing all of his stuff remote right now.
But that will have that referral form, which will give you information regarding the in-home devices. You have a couple of choices. The testing requirements would begin immediately, which means first thing in the morning, you'll need to begin your testing. Mr. Williams, do you have any questions? Or
No,
any other comments? I will allow other comments.
Well, listen, I think you do a great job and I appreciate you. I think that's a unique approach. How about that? It's all good.
Okay. No worries. Thank you. Thank you for your appearance this morning, gentlemen, and you are free to leave the meeting.
Have a nice day.
Thank you.
You too.
All right. Last one is it's a more straightforward case. Yeah, I'm getting called out for spoiling clips too much, so I'm trying not to do that. But I do have a bonus clip. I have a bonus clip after this, but it's going to be a premiere for tomorrow or a release tomorrow. I don't know. It's going to be out tomorrow. But I've got 2 videos, and as always, I'm going to ask you guys which one you want to see. Now, these are the options. So this clip is we still have probably 20 minutes left of this video, and then I'll have a bonus clip that's about 8 minutes long, 8 to 10 minutes long. Bonus clip options. We get to watch a guy held in contempt, which are always fun, dumb people talking back to the judge, always fun. Or we get to hear probably the dumbest defense when it comes to robbing a bank. And when I say the dumbest, I mean it is something that maybe your 8-year-old would try to lie their way out of. That's how bad the defendant's story was of robbing this bank. He's like, I didn't do it. It was, X, Y, and Z. I'm not going to spoil it, but those are the 2 options. We get contempt or dumb defense. So I'm going to ask again about halfway through this clip, and then we'll see where it is. All right, let's go. You know what? Let's just do a poll. I'll do a poll.
On the record in state of Michigan versus Johnny Hinton, 2400419 FY.
Matt Nagel for the people.
Stephen A. Freeman, Public Defender, on behalf of Mr. Hinton, who is present.
And you, sir, you are Johnny Hinton?
Yes, ma'am.
Thank you. All right, on the record, and I'm sorry, we have previously been together and accepted a plea to misdemeanor domestic violence with consideration of 7694A status. Today is the date for sentencing, and we have a pre-sentence report which basically reflects Mr. Hinton did not cooperate with the pre-sentence investigation. Mr. Nagel, you've had a chance to review that?
I have, Your Honor.
Mr. Freeman?
Yes, Your Honor.
I guess I really can't even ask for additions, deletions, or corrections because he wasn't here. Mr. Nagel, on behalf of the people?
Your Honor, we'll defer to the court, but I do think it's relevant to the proceeding today that it appears that the defendant has already refused to cooperate with the court's orders and requests by failing to show to the interview. So we'll defer to the court.
Is Cynthia Solis present today? Okay. Mr. Freeman.
Good morning, Your Honor. Thank you very much. I read the document titled No-Show Report dated April 30th, 2024, authored by probation agent Joseph Sumter, and I shared that document with my client. We both have.
Oh, Steve, I'm so sorry. I saw you. I popped it up, but I was so excited about the bonus clip. I forgot to bring you back up on the break. I don't want to forget about it. So, Steve, thank you so much for becoming a new member. I very much appreciate it. Thanks, man. And hopefully we'll see you on Monday night.
Reviewed it. And from my perspective, I sensed two issues that the court would be concerned about. The first is the allegation that Mr. Hinton did not appear to the probation department for a pre-sentence investigation report, or more particularly an interview. And secondly, that he failed to, I guess, sign up for or participate in the batter intervention program at PATS. In response to that, I would indicate to the court that my client has represented to me that he didn't have any notice as to a date certain or a time certain with respect to appearing to the probation department. Also, the program at PATS, he has a handwritten note that indicates to essentially sign up for that program within 14 days, but there's no indication of the organization or the address or the telephone number as to how to go forward to contact those folks. So I just offered that for the court's consideration. The second issue that, at least to my—
Oh, I'm releasing them both tomorrow. So when I do a bonus clip at the end of a live, it's always a video for the next day that I just have ready. I just have 2 videos ready tonight. So they're both going to be released tomorrow. But yeah, so, and it's not the same case, peeps. It is not. They are 2 different. One is Judge Goggins. Judge Goggins is the one who gets laughed at and holds the guy in contempt. The other one is a new court to me. I've only been watching it for about a week, maybe 2 weeks. I don't think I've grabbed anything from that court yet. So this might be the first time I'm covering it.
My mind was that on the one hand, the victim in this case did not provide an impact statement, but she also indicated that Mr. Hinton is not a suitable candidate for probation. I did not read anything that substantiates that opinion. So I would ask the court to not give it any weight whatsoever. The last is the issue of whether Mr. Hinton is eligible for probationary status pursuant to 769.4A. My reading of this report is that there was apparently an out-of-state conviction for a misdemeanor battery. On the other hand, that was September 27th of 1999. My client's date of birth is 1985. So he would have been at most 14 years old. And the date of offense for that is not shown here. But in any event, Mr. Hinton would have been 13 or 14 years old as of September 1999. Mr. Sumter, the author of our report, indicates that on the one hand, Mr. Hinton would not be eligible for 769.4A probationary status in light of the fact that there was a prior conviction for an assault of crime. On the other hand, Mr. Sumter did intimate that if he was a juvenile, that he would still be eligible today as an adult.
Well, I'm just gonna stop you because I'm looking at his criminal history here. And not even mentioned by Mr. Sumter. There appears to be a May 2nd, 2002 conviction for aggravated assault in Chicago.
That was not included in my copy of his report.
You mean the no-show report?
Right.
Because it's a no-show report. It doesn't have a thorough criminal history. But I'm telling you, I'm looking at the criminal record here, and that's what it appears to state, is that he was originally charged burglary, and that he ended up with a conviction for aggravated assault in 2002. Now, if it relates back and it's the same one, it might be a juvenile offense, 2002. What did that put him at, 17-ish?
Born in 85.
Yeah. So maybe that was also juvenile. And that one's more clearly adjudicated juvenile. It looks like it's adjudicated as a juvenile.
This poll is extremely close. I'm amazed how close it is, actually. If it ends up 50-50, I might just play both. I'm still releasing them both tomorrow. I mean, why not?
The battery was even before that. Okay. All right. Sorry, Mr. Freeman. I was seeing that and I just wasn't sure how that impacted your argument. Go ahead.
Thank you very much, Your Honor. I confess I was totally unaware of that. The Public Defender Office has access to iChat, ICHAT, from the Michigan Department of State Police, and I confess openly that it is not necessarily the most accurate data because my copy of Mr. Hinton's iChat showed 2 alcohol.
All right, I'll actually do this if you guys think this is a good idea, because I gave you more information about the bonus clip. I feel like no one even cares about the clip I'm even playing right now. At least, you know. Anyways, because I gave you more information, do you want me to close the poll and restart it? Because you guys might have a different vote now that I explain the cases a little bit more. Let me know. Let me know.
Related driving offenses only.
Well, those are Michigan. So the problem you're having is you don't have access to out-of-state information.
Right. All of that to say that I think that the failing to appear for pre-sentence interview and failing to sign up for the program at PATS are explainable. Mr. Hinton indicates to me that he has otherwise complied with all the terms and conditions of his pretrial release. Most importantly, he's not had any contact with the complaining witness in this case. And therefore, I would, on his behalf, respectfully ask the court to sentence him to a term of probation pursuant to 76948, if that would please the court. Thank you.
So before I get your statements, Mr. Hinton, the paper you have in your hand is the probation referral I hand wrote, which triggered the probation department to give you the information you needed for your pre-sentence interview and for your referral to programming. I don't buy it. You're selling Mr. Freeman a bill of goods. You were provided the information you needed. You also conducted yourself in a similar way on bond, wherein you were supposed to be in court and you said you came here and someone told you to leave, and that was not really appropriate either. So go ahead and tell me what you'd like me to know before I give you your sentence.
Me coming here was on record. I have a GPS monitor on my leg, and I have the paper that wasn't handwritten from you.
Yes, that is. That's
from the 5th floor.
That is a copy of what I wrote, sir. I have it right here, the pink carbon of that. That is my handwriting. I wrote that to send to probation. I know exactly what you're holding. Mr. Hinton, I'm trying to decide right now whether you do 93 days in jail or whether you do a week in jail and then you do probation. So you go ahead and tell me what you'd rather do.
Of course, I would rather do the week. Well, I'd rather do no days in jail, Your Honor.
That's not happening based on your conduct on bond.
I did everything I was supposed to do. And like I said, the paper says be here May 6th. I was here May 6th. Came here April 4th. Me and Mr. Freeman was here, and we both were told we was not supposed to be here.
On what day?
Was it April 4th or something?
Yeah.
We both showed up here, and then we were told we were not.
No, you were here March 28th, did your plea, and you got that piece of paper that day, so I don't know what you're talking about.
It was a date, we believed it was for sentencing. I don't have it in front of me, but I can represent to the court that Mr. Hinton is factually correct in the sense that he appeared, I appeared, and we actually met on the first floor. And he indicated to me that he had just been up here and had been told that that matter had been adjourned, I believe was the word.
Never happened.
Until, okay.
I have a file. I have the date I wrote in the file when we were actually here and I granted him out-of-state travel. I have the notice that was printed and handed to him, stamped by my court officer the day we were all here, March 28th. So it was never adjourned. This is the date it was, has been, always will be. This is the date it was.
Your Honor, I'm
We
not
can't settle
arguing.
in April, Your Honor.
I'm not arguing with.
If he has another case, that could be something. I have another
Yeah,
file
April.
to arraign him on because he didn't show up for a show cause or something. Stapled together for some reason. Someone got rogue with the stapler. He was supposed to be here April 25th for a show cause. Could that be the court date that he's confused about?
It could be.
All right, I was trying to find a good time to pause it. Vic, thank you so much. Thank you so much for the $10 super chat. I'm guessing you're saying dumb as you want the dumb defense video is what you're saying. And you're not calling me dumb. That's how I'm gonna take it because I like you, Vic. That's how I think. That's what I think that means. But thank you so much for the super chat. I know what you mean. I appreciate it. Thank you so much.
I just want the court to know I am not arguing with the court. I'm not challenging the court file.
I don't really think it's you, Mr. Freeman. I think it's Mr. Hinton.
This is Judge Buchanan. Buchanan, I believe. I think that's right. I think it's Judge Buchanan. She's out of Lansing, Michigan, I believe. I'm getting better with my Michigan cities. The more times I go there, I'm realizing that everything's not Detroit.
He's selling you a bill of goods. He's trying to convince you that he didn't understand what he was supposed to do or where he's supposed to be, and I don't buy it. I think he purposely, what do they call that? Weaponized incompetence. He purposely doesn't understand or do what he's supposed to so that he doesn't have to. And that's not going to work out for probation, because if I give you specific rules to follow and then you claim you didn't understand and you're in violation, you just end up in jail anyway.
I'm not understanding what rules I violated.
What, pardon?
I'm not understanding what rules I violated.
Well, show up to court, go to your pre-sentence interview,
can't
sign
go
up
to
for the
court.
class.
I don't talk when she's talking.
You asked me the rules. I'm telling you the rules. Those are the rules that you violated. I have to decide.
Yeah, Sarah, when I mean, this is even, I think 2 or 3 weeks ago, I had a Lansing case. I'm like, I don't know where this is. It's somewhere in Michigan. It's probably Detroit. Like, no, it's Lansing. That's not Detroit. And then I had another case. I think it might have been even the same video. I was like, oh, this, I think this is Detroit. And no, that one was Georgia. I just call everything Detroit. When in doubt, I just say Detroit. Tupac, thank you so much for the 5 gifted memberships. I appreciate it. Appreciate it. And welcome to all the new members. Thank you all so much for hanging out. And yeah, let's go. Thanks, Tupac.
If putting you on probation makes sense. Like, are you going to successfully complete a term of probation and change your relationship dynamic? Or are we just dragging out your jail sentence, wasting your time and your money on something that isn't going to amount to anything for you?
No, Your Honor.
Anything else you want to tell me today? It's not going to be about how you didn't understand where you're supposed to be, because you know I'm not interested in that. You can tell me.
No, Your Honor.
All right, based on my review of the criminal history, I do find that Mr. Hinton probably is eligible for 7694A. And in the light of the fact that there's confusion about his record, I would find in favor of Mr. Hinton allowing him to earn a non-public record of this offense should he complete a term of probation.
Yeah, the judge isn't buying the attorney or the defendant right now. She's just like, man, can we just get this over with? Mike, I never remember to hit the like until someone says it in chat. Even on my own videos. Never remember until I see someone do it. It's just not it's not a first reaction for me anymore. It always used to be, and for whatever reason it's not. I'll go in, I'll jump in early, and I'll be waiting for, a big stream to pop up, and I'll be a half hour in and I'll just look at the chat and see someone say, "Hey, hit the like." I'm like, "Oh man." That's why they're mods. That's why there are mods, because they're awesome.
So during your 12 months on probation, you are to meet with your probation agent as directed. Don't leave the state without permission. Do not commit crimes. You're not to have any contact with Cynthia Solis without consent of the court. So that no contact order continues. You are not to engage in assaultive or threatening behavior. Do not use alcohol, marijuana, or controlled substances without a prescription, and submit to random testing as directed by your probation agent to prove your sobriety. You're not to attend any bars or nightclubs. You must enroll in the domestic violence program within 10 days. You may have your GPS tether removed after you've completed the weekend plus 2 sessions of that program. You are to maintain your employment. You are not to purchase or possess firearms, ammunition, or weapons of any kind while on probation. Your fine is $250, crime victim rights fee $75, statement of costs are $50, and oversight fees are $30 per month times 12 months, so $360 for a total of $735, which you may pay over the course of your probation. You had to choose between paying for a class or paying us pay for your class, because you have to do the class to earn that 7694A status. You have to do that class to complete this probation. As long as you're making good faith efforts paying us, you can finish this.
Cindy, thank you so much for the 5 gifted memberships. Got a lot of memberships being gifted tonight. This is awesome. Welcome to everyone who's received a membership tonight, a gifted membership tonight. You guys are all awesome. People who have gifted, very generous of you. Thank you. Everyone's awesome. All right, so I'm gonna end the poll after this pause. You know what? Actually, Chris Barton, thank you so much for that PayPal. Very generous of you. And no, you're my friend as well, and you're awesome. You're awesome. Thank you so much, Chris. I appreciate it. All right. I'm gonna the poll's almost over. The poll's almost over. You got about 30 seconds before I end the poll. Just saying.
Probation still owing us money, but you cannot finish this probation if you're skipping a class. In fact, that 7694A, if you that special first time offender status, if you have a probation violation for not attending your class, committing a new crime that involves violence, or violating the no contact order, I do not even have discretion. I have to take your special status. You violate probation in another way, it's up to me. But those 3 ways are in the statute. I don't have a choice. So remember, being in the class is the primary purpose of this probation. Therefore, it should be a priority for you to make sure that you're paying for and attending that class above all other conditions. Same though, as if you have to take a drug test to prove you're compliant with my sobriety order or pay us, pay for your drug test and we'll wait for the money. Like I said, you can finish the probation with us, owing us money, as long as you're making good faith efforts. But you won't finish probation if you're not doing these other things that I've ordered you to do. If you, your sentence is going to start with 12 days jail with credit for the 5 you already served. Leaves a week to do. If you'd like to appeal my sentence and you need a public defender to assist you, you need to make your application within 14 days. Mr. Warren is going to take you into custody right now, and then you'll need to report to the probation department the first business day after you're released from jail so you can set up your probation.
All right. What do we have? What do we have? End poll. Contempt. You guys want to see contempt? All right. And we're probably going to play both. Now, okay, I do have a rule for bonus clips because they are clips I'm going to be putting out tomorrow. You guys don't have to rewatch them, but I would appreciate if you just jump in and hit the like. That's my rule. That's my rule for bonus clips. You don't have to rewatch them, but please, if you have a minute, jump in and hit the like button. It does help out. All right. There's only about 30 seconds left of this. We can watch him walk off with the officer, and then I'll play the other one.
Orders and start your class. I guess I'm gonna write within 10 days after jail for the program so that it's clear that he has after release. So that he has his 10 days when there we go. Oh, I just need to do one other thing, I guess, as I'm doing that, which is this is State of Michigan versus Johnny Hinton 0900290. Mr. Hinton, this is the show cause hearing. You missed April 25th and you haven't been paying on your fines and costs. You still owe $728. And back in March of this year, you told me you'd start paying $100 a week. You haven't been doing that?
I paid what I supposed to pay.
You believe you've been paying $100 a week like you promised?
I paid. Yes, and it's supposed to came out automatic.
Well, that would only work if you did a wage
I
assignment.
went and wrote out the direct deposit. The automatic change or whatever.
I don't know what you're talking about. I don't think I have a wage assignment in this file, so I don't know what you're talking about.
Yes, I signed it, and then
Who did you sign it with?
Mr. Menwez Rodriguez of Three Amigos Landscaping signed it too.
I don't have a wage assignment. And regardless, until the money's coming out, you're responsible for the payments, Mr. Hampton. Same thing happens in civil cases, like somebody is getting a wage assignment so that they're not garnished, and until the wage assignment starts, they have to make the payments. Let's see here.
Well, Chris gets whatever she wants. So yeah, Legal Fiction, thank you so much for the super chat. I appreciate it, buddy. I do. And yeah, Chris demands this pause. Then we're gonna pause for Chris.
All right, so it shows 0 payments if they made. And Mr. Hinton, I wrote that you're willing to do a wage assignment, but there isn't one. So you're gonna get payments in here?
Yes.
How much can you pay?
I get paid now if I could go.
Yeah, I know you got a certain sentence right now.
Yes.
Okay, that's a separate case. So you were planning to pay $100 a week, but I know you got to pay for this class.
Thought it was monthly.
You told me per week. That's what you told me. And normally I are monthly, but you said something exceptional. But I know you got to do jail and you're gonna have to pay for that class. So I'm gonna put $100 a month beginning May 31st. So that you have a little time to get some things in order. If you can't pay on May 31st, let us know that you need more time and we can change that date. You're all set there, Mr. Mann.
All right. Bonus clip time. Did you guys think I was just gonna walk away? I thought we still had about a couple more seconds. All right, let's see. What won the poll? Contempt won the poll. Where are you at? All right. Yes, I will fast forward my intro. You guys don't need to see this, especially if I end up playing both of them. But yeah, like I said, video's already ready to be released tomorrow. This is Judge Goggins. This is, yeah. I don't know why, but I always find it humorous when, you're a defendant and, all you have to do is say please and thank you. That's pretty much all you have to say when you just walk away and you just get to go live your life and you decide to be an idiot for no reason. This guy is the definition of being an idiot for no reason. All right. Contempt hearing. Let's go.
How about Michael Lettington?
Judge Attorney Skinner, on behalf of Mr. Lettington, identify yourself. Michael Lettington. Is this a reissue, Judge? I know one of those I had this morning was a reissue.
Okay.
I'm not sure if it's Lettington or.
I've got two files. One is.
Oh, also real quick, something to note. For whatever Judge Goggins has one of those courtrooms that when he does in-person hearings, the audio is terrible. This is actually, I maxed out the volume. It was a lot lower, but because I maxed it out, there's that annoying kind of feedback in the background. But we can hear him. But yeah, his in-court audio is not that great. I want him to stick to Zoom because he's a great Zoom judge and you can hear everything clearly. But yeah.
052 is it? Oh, they're both domestics. Let's see what we did. Leave on for jury.
That's exactly it, Annalisa. That's exactly it. He might be one of the kindest judges on the bench. I've seen some people be downright disrespectful to him, and he's just like, okay, file your appeal. That's your right. And that's all he says. This is the first time I've ever seen him hold someone in contempt. I know I spoiled it, but I told you guys that this is a contempt hearing, so you already know. It's not a contempt hearing. He gets held in contempt. So it is a spoiler.
On file 052, it looks like he failed to appear on April 11th for jury trial. So I issued a bench warrant on that matter. And actually on the other one, same thing, April 11th for jury trial, failed to show up, so I issued a bench warrant. On both of them. Why didn't you show up?
I was in jail, Your Honor.
On something else?
Yes, which is dismissed.
Okay. When were you in jail?
Around April 11th.
Around that time period?
Yes.
Okay. I'll recall the bench warrants.
If you're talking about the thumbnail, yeah, I know. Here's a little secret on the YouTube side, on the creator side. When you misspell a word like that, when it's a grammar error, then yeah, I'm embarrassed by that. But when I misspell a word like that, I will get 30 comments from people telling me I misspelled that word, and that's engagement. I did it on accident when I first started my channel. I actually had a date wrong, is what I did. I put the wrong date, and I had 100 people tell me that I put the wrong date on it, and that video blew up because of all the interaction on the video. So I tend to dabble in inconsistencies and spelling some words. That one was on purpose. Sometimes they're not. Yeah, grammar errors are not on purpose, but that one was.
Set new. You might as well just leave him on for jury trial date. He's been through everything, so leave on for new jury trial date for. It's June.
June 6th.
6th. For June 6th. At 8:30, so that's in person, it'll be right here, okay?
Yes, Your Honor.
And we'll reinstate a
$10,000 personal recognizance fine in each file. Same conditions though, that there be no contact.
That was lifted, Your Honor.
Well, not for me, it wasn't.
Last time I seen you.
Oh, no assaulted. Yeah, I got no assaulted, so.
Yeah, because we
That's
lived together, so you lifted that a long time ago.
Well, I said no assaulted, so that wasn't that long ago, April 11th. We did that too, and that day just.
Yeah, we had a Zoom court and, both of the victims also called
So
in that court.
don't tell me anything about it, okay? You were just.
I don't care, I'm innocent, so.
Sir, keep your mouth shut, okay? You understand it?
Yeah.
Don't talk over me, I don't want to hear anything other than what I'm asking.
All right.
You gonna start laughing now?
Yeah, it's fine, I'm just.
Say, have a seat up here. Come on. Not gonna disrespect me, not gonna disrespect, sit down. Sit down there.
What seat?
Right there, right there,
This one?
right there.
This one?
Which one am I pointing at?
The one to your right.
This, okay.
Jeez, man. Get yourself in trouble right off the bat.
I'm not in trouble, I didn't do anything.
Sir, you are now with me. You know what, let's just have him right now, Mr. Skinner. He's gonna give me an attitude. Anything else? I'm gonna remand him anyways. $10,000 cash surety bond on each file. No contact with the alleged victim on these matters, GPS tether.
Oh, it's not over. This clip is only halfway through. They hear another case, which I'll fast forward here in a second, but it is not over. He gets mouthy. Yeah, he's in shock right now. He doesn't know what's going on, but his mouth comes back.
That attitude, I'm concerned you're not gonna listen to what I'm telling you.
No, I don't have an
Yeah.
attitude with you.
Sure you do. Sure you do. Just keep quiet now. Charles Richard?
Just have a seat, I'll bring you paper.
Okay. Organized, right, just- It's your two years.
Yes.
What's going on? Give me your.
It's going on James.
Yeah, I got my phone, I was expecting, I have to notify my kids are in school. I have to take them out.
All this right now.
Well, I wasn't expecting to go to jail, and I told them I have to call my wife. And I just told her to pick up the kids and raise that.
When we get back to the call, we'll make sure we can get them.
Where, because I've already been through this. Right, this is ridiculous. And so I'm gonna be in jail for how many days? Dude, I'm suing you, dude. I didn't do anything. I'm on court till June 6th. I can't sit in jail for, Your Honor. Your Honor, mate.
So we're done right now.
Your Honor, I can't sit in court for, I didn't do anything, Your Honor.
Listen, we're gonna talk about when you get there.
This is crazy, Your Honor. I can't wait until June 6th. I have to take care of my kids, Your Honor. Can we figure something out? Your Honor? Like, But look, I'm going to jail for something I didn't even do. This is illegal. Dude, this isn't right, man. This is illegal, dude.
You don't want to pick up a resisting and
But I
obstructing
didn't do
charge.
anything wrong. I don't know.
We'll call the jail and find out what's going on. Who's got the kids? Who has the kids?
My kids are in school right now.
Okay,
I'm the one to pick up
is there
their
someone at home that can pick the kids up?
I hope so. I have to call them.
Well, I'll do the calling. What's the phone number?
Okay, all right.
Write it down.
What are you doing?
It's 586, or actually, I don't even know. Let me get it. This is ridiculous.
Dan, why don't you come on here? Come on here.
Hold on, I'm giving him his number. Turn around. Can I give you the number?
Relax.
Oh, my God. Hold on, let me put my phone in my pocket.
No. We're gonna make the phone calls for you. You gotta
This is
relax.
ridiculous, dude. This is a big joke.
Meeting ID 647-876.
I'm not even understanding this whole case, dude.
All right, so while all this is going on, that lady was recording it, and Judge Goggins just took her phone away. That's what just happened. Oh, all right. There's about 10 seconds. All right, you know what? Call Mr. Allen. Yes, that Mr. Allen. He wouldn't be talking if there was a Mr. Allen there. I'm just gonna say, Mr. Allen is a giant of a man. All right. Like I said, there's about 10 seconds left of this, and you know what? Because I'm feeling generous, also because our good friend Vic wanted to watch this one, I will play this one as well. Again, the only rule I have, or not the only rule, I'm not going to say it's a rule. The only thing I ask is I am going to release these both tomorrow, so please make sure you just click on the video and like it. You don't have to watch it again, but I would appreciate you just clicking on it and hitting the like button. All right, let's play the last couple seconds of this, and I'll play the next one.
They called and asked for dismissal. What? I have work, dude. I have to take care of my family. Dude, this is a joke.
I don't know.
Sorry.
No, let's address that at the yeah. No,
All right, Judge Goggins just muted the court. He's like, I don't want this on the record anymore. All right, next one. That's it. I don't. Oh, what did I just do? I think I just hit the wrong button. Oh, here we go. World's dumbest defense. This is a good way to end it. You guys are going to laugh at this one. You are going to laugh at this one. Again, intro's in there because it's going to be released tomorrow. This is Cass County. I don't know the name of the judge, but the court is called Cass County. That's all I know. And I just started watching this court about 2 weeks ago. And when I start watching a new court, or when a new court comes up on my screen, I hyper focus on the court because I want to use it. It's like, I haven't used this court before, so I want to use it. And I don't see this court. I don't think I've seen it anywhere.
Inheritance very quickly started in.
Oh, I also need to say, this was about an hour-long hearing, and they went through the facts of why he was being sentenced. So this is an actual sentencing. So I don't know if it was by jury or if he pled. I don't know the details of that. But this was an hour-long hearing, and I went through, I skipped the attorneys saying why he should be sentenced to certain things, because that was just kind of run-of-the-mill stuff. So this is where it's funny, when the attorneys stop and the judge is imposing sentence. That's where we're picking up right now. What state? I don't know. Is Cass County really North Dakota? I had no idea. No idea. I just know it says Cass County Court on the YouTube channel. That's all I know. But it is spelled that way, CASS.
Went back to using marijuana, which she said she noticed that he'd been using it at increased the cognitive impairments that he was having. And then even by his own statement, he was on his way to Kalamazoo to get more pot. So he's continued, obviously, even in his own statement, to indicate that he is going to continue or was continuing to use marijuana.
And so I understand the prosecutor's request as well that the court exceed the guidelines. I'm also, I guess, a little, I think, taken aback, probably maybe all of us were, even Attorney Drake, I don't know, to think that you'd have a bank robbery that would have guidelines 19 to 38 months. It just seems like an offense that's so serious in society that we've kind of all heard. But you know, I don't set the guidelines. I'm only here to review them and make a decision based on those guidelines. So, but specifically in this case, Mr. Love, on April 16th, you were convicted by a jury here in this court of bank robbery and larceny in a building for robbery of the Fifth Third Bank in Cassopolis, at which you stole somewhere between $1,500 and $1,600. The offense occurred on February 27th of 2023 when you entered the bank wearing a motorcycle helmet, a face mask, and a t-shirt that quite vividly in the bank surveillance video said cleverly disguised as an adult. Had a smiley face on it as well. You pulled out $2 yellow dollar general bags on the counter, put them on the counter, told the teller to give you the money in the top drawer. Interestingly enough, an FBI agent from Grand Rapids who had been familiar with you from the prior bank robberies that have been referenced here that occurred in 2013 identified you from the surveillance video. And she and fellow agents went to your home in South Bend, located the van you used, which had been observed here in Cassopolis by a video that was owned by Cass County Sheriff's Department. Joshua Zilke, a home surveillance video, observed your van driving on the road behind the bank numerous times on the afternoon prior to the robbery. And that, when we look at the time frames and the number of times that your vehicle was driving down that street, it just smacks totally against the description of the offense that you give to me. When the officers did arrive at your home in South Bend, the special agents found in the van the motorcycle helmet with the face mask in it that you had been wearing when you went into the bank, which was clear from the surveillance video. When the agents went to your home, your wife was able to provide them the smiley face t-shirt you were wearing, which she had just washed and put in the closet. Both your sister and your wife also identified you from the bank surveillance video and testified to that fact at trial. You know, Mr. Love, you're 70 years old. This is obviously, this is not your first bank robbery conviction. You also had a prior attempt back in 2013 that was dismissed when you went to federal prison in Grand Rapids for approximately 7 years, followed by supervised release, as we've talked about here, which was based on a compassionate COVID release. You were paroled in this matter in May 20th and discharged in June 21, in June of 2021. Then a year and a half later, you're at it again here in Cassopolis. In this matter, you stole a mere $1,500, and as a result, you're looking at another lengthy prison sentence here today. You know, Mr. Love, I don't know, is it really worth it? When you figure the time that you get for the money you steal, which incidentally you didn't get to keep, you'd be better off, in my opinion, getting a part-time job as a Walmart greeter. You know, bank robbery.
That was a shout out to Michelle. Michelle, you just got a shout out from a judge. Michelle's our favorite. We call her the Walmart greeter of the chat because she says hi to everyone that comes in, which is why we love her, and she's awesome. Hopefully she's still here.
Didn't end up well for Willie Sutton, John Dillinger, Bonnie and Clyde, Babyface Nelson, Pretty Boy Floyd, Ma Parker's sons, Machine Gun Kelly, nor for the Over the Hill gang, which is a category you fall in, Mr. Love. If you do get out of prison, you'd be better off getting people to pay you a penny for your thoughts, and you'd be a heck of a lot farther ahead. And when I read your description of the offense in the pre-sentence investigation, I was driving northbound on M62 when I spotted a hitchhiker.
All right, this is the story. This is what makes this video so good. It's this story. So I haven't said this all night, so I'm going to say it this one time. It's about to go down.
I picked him up. We drove around Cassopolis, a hitchhiker. I loaned him my van at the War Memorial. He drove away. Now, most people don't loan their van to a hitchhiker, someone you don't know, let him drive away, and then you go on and say, when he returned, I could see a large amount of cash in a Dollar General bags. We drove to the Shell station in Dowagiac. I was afraid he might have a gun. I didn't warn anyone about the presence of the robber in my van. He walked into the streets of Dowagiac calling the amount of money he'd stolen chump change, and that I could have it. Now, I understand, it's preposterous that you would loan your van to a hitchhiker. It's preposterous to believe that he would go commit a bank robbery wearing your t-shirt, wearing your helmet that was found in the van. It's also preposterous to believe that someone that would do that would then leave all the money for you in your van and tell you could have it. And what do you say? I was driving to Kalamazoo anyway to buy pot. I decided to call the authorities to tell them what had happened, but I fell on the toilet at home before I could tell anyone and broke the toilet in pieces. I spent the next few days in the hospital in South Bend and got out, and my wife and I bought a toilet and replaced it, and minutes after finishing the job I was arrested. I've been an attorney over 40 years, Mr. Love, and I can tell you that the evidence that I saw here in this courtroom at this trial is probably the most conclusive evidence that I've ever seen in a trial of your guilt. This wasn't proof beyond a reasonable doubt. This was proof beyond any doubt. And for you to still have no remorse and to have the audacity, in my opinion, to submit this description of the offense to the court is just incredible. And when I look at that, I look at the letters from your wife and from Marcus Erickson, and they talk about the type of person you are and the type of person that you were. I don't see that when I look at the description of the offense that you gave to this court. To me, you're nothing, you're just being manipulative, you're making up a story, you're not the honest, good person that they portray in their letters. Now, maybe once you were, but in the last 10 years, you've been using drugs, you've been committing bank robberies numerous times, and it doesn't appear to me that you have any intention of stopping. You got off federal parole, and what'd you do? Right back to gambling, right back to blowing your inheritance, right back to using drugs. And I have no reason to believe that if you get out of prison this time, that
he is 70 years old. 70. I think that's what makes this story even funnier. He's 70 years old, and this is an excuse my daughter would tell me. It really is. This sounds like one of her excuses. Well, I was walking home from school, and then this happened, and then I met this person who gave me this pack of gum, and no, I didn't steal it from the store. It was this random person that I've never met before that handed it to me and said, I've got all this gum, I'm trying to get rid of it. My 8-year-old would tell me that. That's exactly my 8-year-old story. I just made her sound like a thief. No, she's never done that. She's never done that. I'm just saying that would be where her brain went. He's 70, and that's the best he came up with.
You're not going to go back to do the same thing. I believe, as the prosecutor indicated, that there should be a deviation in this matter. When I look at your history of the offenses, I look at you being spending 7 years incarcerated in the federal system and being on their parole, turning around then right after that, instead of taking advantage of the compassionate release from COVID and bettering your life, you turn right around and go back into those same ventures. And so I agree with the prosecutor, there should be a deviation, and I believe that it is appropriate to deviate above the guidelines when I look at everything here in your background. So what the court's going to do is on the count 1 charge of bank robbery, it is sentenced the court, you be committed to Michigan Department of Corrections for a minimum term of 48 months to a maximum term not to exceed 40 years with credit for 435 days already served, and which this court determines is proportionate to the seriousness of the crime committed and appropriate when considering the reformation of you, the protection of society, and the deterrence of others.
All right, it is that time now. I've been streaming for an hour and 45 minutes. Man, I must really like you guys. All right, I am going to let this play out. Let me know which one, now that you've seen them both, which one did you like better? Did you like the dumb defense, or did you like the guy getting held in contempt? Now, yeah, I don't know. I think this one was a good to finish the night off because I think everyone was laughing. So it was a good way to finish the night. So I think that worked out well. Anyways, let's go hang out on Discord for a little bit. And yeah, that's all I got. You guys are all awesome. Thank you so much for your super chats, the PayPals, the gifted memberships, the super chats. I think I'm repeating myself now. That's how you know I'm getting tired. All right, you guys have a great night. I'm releasing both these tomorrow. Remember, if you don't mind, just jump in and hit the like. You don't have to watch it again, but you may because they're both really good. But you guys are awesome. If I don't see you in Discord, I will see you tomorrow. Remember, I do take Saturday nights off. I am releasing both these, and now, but I still have to do my travel video too, and I want to release that tomorrow, so I don't want to keep pushing that off. So I try to go live sometimes, like kind of middle of the afternoon on Saturdays, but I might not tomorrow. I might just put up these 3 videos and that's it. Anyways, that's a conversation that I'm gonna have with future Colin. All right, if I don't see you in Discord, I will hopefully check you guys out tomorrow. Until next time, bye.
In addition to the commitment, the court will order to pay $68 in minimum state costs, a crime victim rights assessment of $130, court costs in the amount of $500, which the court deems reasonable based on the average cost of prosecuting a case here in the county, and the court will order to pay $350 in attorney fees to partially reimburse the cost of providing you legal assistance in this matter. On the count 2 charge of larceny in a building, it'll be the sentence of this court that you serve 435 days to Cass County Jail with credit for 435 days already served. In that matter, you'll pay $68 in state minimum costs and a fine of $500. Court will also order that you pay restitution in these matters in the amount of $305 for the benefit of Fifth Third Bank. I will advise you, Mr. Love, you do have the right to appeal your sentence or conviction. I'll have the deputy there provide you with notice of your appellate right to review. He's going to have you initial receipt of that information. You'll receive 2 copies. If you did wish to appeal your sentence or conviction here today, Mr. Love, you can fill one of those forms out, return it to the court within 42 days of today's date. And if you qualify for the appointment of an attorney at public expense, the court would appoint an attorney to assist you in your appeal. Anything further in this matter, Prosecutor Fitz?
No, Your Honor.
Attorney Drake?
Nothing, Your Honor.
Mr. Love, any questions for the court?
No.
All right. We'll go ahead then and commit you back to the custody of the Cass County Sheriff to be committed to Michigan Department of Corrections to serve the balance of your sentence.